I'm attorney Peter Goodman. I'm a partner at Berger, Fisher, Schumer, Wessler, and Goodman, where I head the real estate department. We have offices across Long Island and New York City. Today, we're going to talk about the property condition disclosure statement. It is part of the real property law. It's an amendment to an existing law that was intended to provide transparency in real estate transactions. Traditionally, buyers bought under the caveat emptor principle, meaning let the buyer beware. They were buying as-is properties. But the law intended to create more transparency by having sellers fill out a form that was called a property condition disclosure statement, which disclosed certain things that the seller knew about the condition of the property. The problem was it had a $500 opt-out, which said that the sellers could just pay $500 to the buyer at closing, and then the buyer had to take the property as is and did not get a chance to review or receive that property condition disclosure statement. So sellers always just gave the $500 and avoided liability. So in March 20, 2024, they changed the law, and now the law requires the property condition disclosure statement to be completed by sellers and provided to buyers, and there's no $500 opt-out clause, so all sellers have to complete it. We're going to talk about the who, why, what, when, and where of this law. So the who is residential real estate. Commercial real estate is not affected by this law. It's only for residential real estate. There are some exceptions. Exceptions are a vacant land contract, a co-op or a condo, a property that's in a trust, a property being sold by a fiduciary, such as in an estate when an executor or an administrator is selling. There are some other exceptions that are not as common. I don't want to get too far into the weeds and talk through those, only because I don't want to spend too much time on something that's not going to affect most of you out there. Let's talk about the what. There are now 56 questions. This is actually a questionnaire that has general and environmental questions on it. You can answer yes, no, unknown, or not applicable. The 7 new questions that they have now are about flood areas and floodplains. So it's something that sellers will complete and send over to buyers. Sellers, though, have no obligation to conduct any type of inspection in order to answer the questions. The seller just has to give their actual knowledge. They do not have to do inspections, so it's based on only what the actual knowledge of the seller is. A seller who willfully fails to provide it could be liable for actual damages, statutory damages, or equitable damages, so they could be sued, basically. Let's talk about the when and where. So you get the form from your real estate agent. The law requires the realtors to provide and inform the sellers of the requirement and the buyers of the requirement. An agent has a duty to inform. Don't expect the realtor to answer the question, though, or help with the questions, because they have been instructed to tell you to speak to your attorney. This has been what the New York State Association of Realtors is advising real estate agents to do, and it is actually the right decision, because it really is something you should speak to your attorney about. And it's another reason why you should hire your attorney at the beginning when you first start looking at property or first start deciding to sell your property. I get a lot of people that approach me and call me for legal counsel when they already have an accepted offer. And I think it puts you behind when you don't hire your attorney up front. You should always get your team in place as soon as you decide to enter the market. So the what and where, or the when and where, I should say, is it has to be included with the contract of sale. So that is when you provide, as a seller, the document. You provide it when the contract is provided. It has to be included as part of a fully signed contract. It's an attachment. If anything changes between the time the seller originally fills out the form and the date of the closing, then it has to be amended. There's no obligation of the seller to say or amend the document after closing, but they have to amend it if, let's say, the roof starts to leak or there was a problem with the property. That has to be disclosed on the seller's property condition disclosure statement. and it happens after the seller filled out the form, but before you actually go to the closing table and to turn over the keys, then the seller is supposed to amend the form. So, best practices: get your attorney early. Property owners must complete the property condition disclosure by themselves, so you have to complete it by yourselves. Don't ask your realtor to do it. You can call your attorney to discuss it, but you have to complete it by yourself. Complete it to the best of your actual knowledge. Doesn't have to require you to do any inspections. You just have to complete it to your actual knowledge. Maybe a good idea to check if you're in a flood zone, though. That is something that is easy to find out. And nothing prevents agreements between the buyers and sellers that change the representation. So if you already know that the roof is leaking or an appliance is not working or you're missing a certificate of occupancy, nothing prevents you as a seller from negotiating that with the buyer and having a clause in the contract that represents to the buyer that they're not getting that certificate of occupancy or that part of the property in working condition. That is perfectly legal as long as it's in contract. If you are a buyer, you should read the answers to the questions and understand what is being represented, because that's how you're buying the property. It is still an as-is sale. It's just that you're getting the property condition disclosure statement, which means you should be doing inspections, whether the inspection is just a regular home inspection, whether it's a septic tank inspection, a pool inspection, radon, termite inspection. There are all sorts of inspections that you can do, but you are expected as a buyer to do your due diligence and do those inspections before you sign a contract with a seller. Don't count on the property condition disclosure statement. It is not a warranty. And if the seller misrepresented or made a material misrepresentation on the statement, yes, they may be liable for damages, but the reality is it may not be so easy to sue them. If let's say the damage that was caused to you was $2,000 and something they had to repair because of material misrepresentation by a seller, well, are you really going to sue them over $2,000? Probably not. So the property condition disclosure statement does provide more transparency to buyers, but it is not the end all. You still have the same obligation as a buyer to do your inspections. It really doesn't change that much about the process. It just requires that the form be included with the final contract of sale. But other than that, the process is primarily the same for purchases and sales, and buyer still has an obligation to purchase the property and do their due diligence, and it's an as-is sale. So that's everything. If you'd like to reach out to me, feel free to email me at RE, as in real estate, RE@bfslawfirm.com. That's B as in boy, F as in Frank, S as in Sam, lawfirm.com. You can reach both Long Island and the New York City office through 516-747-1136. You can also check out our website at www.bfslawfirm.com. I wish you luck in your purchases and sales, and I'll see you at the next video.